This is part 6 and the conclusion of constitutional law, looking at the regulation of time, place, and manner of expression. What is a public forum? You have traditional public forums. These are historically associated with expression and include sidewalks, streets, and or parks. You have designated public forums. These are not historically associated with expression, but the government has kept open for such use. This includes civic auditoriums, publicly owned theaters, and after-hour school classrooms. The government can change a designated public forum to not open, but cannot change a traditional public forum to not open. Looking at restrictions on the time, place, and manner of expression, looking at a traditional and or designated public forum, the government may impose reasonable restrictions to the time, place, and manner of expression. Restrictions must be subject matter and or viewpoint neutral, such as content neutral, must be narrowly tailored to serve a significant government interest, and must leave open alternative channels for communication. Looking at residential areas and public schools and regulating expression. In context of residential areas, you have no right to picket a single residence. In the context of public schools, this is generally considered a designated public forum. And use of facilities here, you cannot discriminate against organizations based on beliefs. You may provide funding and or benefits to student groups only on a viewpoint neutral basis. Again, we stated that if a student organization uses school facilities after school hours, any religious or other organization has a right to use that facility as well. And again, if you provide funding benefits to student groups, you must do that on a viewpoint neutral basis. That non-public forum and regulation of expression, time, place, and manner of expression. A non-public forum is a forum that is not a traditional public forum or a designated public forum. So it's everything else. Here you may regulate if the regulation is viewpoint neutral and reasonably related to a legitimate government interest. Just to be clear, for a non-public forum, the government may completely prevent speech on certain issues, but may not select one side of the issue to be presented. Non-public forum examples include post office sidewalks and airport terminals. Regulation of content. Content regulations must be are only valid where they're necessary to achieve a compelling government interest, and they're narrowly tailored to meet that interest. Looking at obscenity and child pornography in the regulation of content, neither are protected. To determine what is obscene, you have to do the obscenity test. This is where an average person applying community standards finds the material taken as a whole, appeals to prurient interests, these are sexual matters, depicts sexual conduct in a patently offensive way, and lacks serious literary, artistic, political, and or scientific value. Here you can consider the attractive women putting themselves naked in cages in big cities to protest on behalf of PETA. In regards to obscenity and child pornography, narrowly drawn zoning regulations to restrict adult entertainment are okay to reduce the impact on the neighborhood, but you may not ban adult entertainment entirely. Looking at incitement to violence in the context of regulation of content, you may forbid content that has a tendency to incite people to violence. Here, the speech must be directed to inciting and or producing imminent lawless action, and the speech sought to be regulated must be directed to inciting and or producing imminent lawless action and be likely to incite and or produce such action. Here, this is clear and present danger. Fighting words and the regulation of content. These are words that by their nature are likely to incite immediate breach of peace. That's from Chaplinsky. Simply annoying and or offensive language is not enough. must be a likelihood of imminent violence. Regulation of the media. The media has no greater protection than the general public. They have a right to publish information, and the public has a right to receive that information. Looking at strict scrutiny applies to regulations of the media. Gag orders in the context of a trial are generally struck down. It's rarely the least restrictive means. Attending trials, it's no absolute right of the media to attend a trial. Where the media publishes illegally obtained private information, the press is shielded if the information is of public concern and the publisher is unaware of the illegal source. Makes sense? They have no idea that it was illegally obtained and it's of public concern. That's the job of the press. Regulation of association. You have a right to form and or participate in virtually any group with virtually without restriction. This is not absolute. It is subject to regulation, is subject to a compelling state interest. Regulation of association in the context of public employment. You may only be punished if an individual is an active member of a subversive organization, has knowledge of the organization's illegal activity, and has a specific intent to further those illegal objectives. And that completes all of constitutional law.